Hello viewers, how are you all today? Today, we will discuss a very important and interesting topic of understanding the concept of negligence. Negligence is a word frequently used to describe ordinary carelessness. Legally speaking, it indicates a failure to uphold the standard of care that the perpetrator acting reasonably in the circumstances would have upheld. Generally speaking, when it was conceivably foreseeable that acting otherwise would probably cause harm, there was a legal need to use prudence. Negligence can result in a variety of different injuries, such as failing to take the necessary precautions. It is widely known that Indian tort law is based on English common law. Because of this, Indian courts adopt and change negligence laws in accordance with moral, just, and equitable considerations. The Latin term negligentia means failing to pick up, is the root of English term negligence. In the broadest sense, the word negligence describes the act of being careless in a legal context. It describes the failure to use the level of caution that a reasonable person in the same situation would have used. English law did not recognize negligence as a distinct cause of action until the 18th century. Similar to the English law, the Indian Penal Code 1860 lacked a provision for intentionally causing someone's death. Nevertheless, in 1870, Section 304A was inserted. The main factor to take into account when determining whether the person acted without exercising due care are the likelihood that the person's action would likely lead to injury, the expected severity of any potential harm, and the responsibility of the safeguards to eliminate or significantly minimize the risk of harm. Someone who suffers losses as a result of another's negligence may be entitled to make a claim for damages to compensate them for their losses. The manifestation of such loss could be physical harm, material loss, mental sickness, or financial loss. A five-part approach can be used to examine negligence law in general, including the evaluation of duty, breach, real cause, proximate cause, and damages. Winfield defines negligence as a violation of a plaintiff's legal duty of care that causes the plaintiff unforeseen harm. Lord Wright states that negligence means more than heedless or careless conduct, whether in commission or omission. It properly connotes the complex concept of duty, breach, and damage thereby suffered by the person to whom the duty was owed. According to Charlesworth and Percy, negligence has three meanings. These are: number one, a state of mind in which it is opposed to intention; number two, careless conduct; and number three, the breach of that duty to take care that is imposed by either common or statute law. All three meanings are applicable in different circumstances, but any one of them does not necessarily exclude the other meaning. In Blyth versus Birmingham Water Works Company, negligence is defined as the failure to act in a way that a reasonable person would, or the doing of an act that a sensible or reasonable person would avoid. In Nihal Kaur versus Director PGI Chandigarh, a pair of scissors were left within the patient's body after surgery. Then he passed away as his condition deteriorated. After cremation, a pair of scissors was found among the remains. A settlement of rupees 1,20,000 was provided to the deceased dependents. Negligence is mainly characterized by three different forms. First one is non-feasance. It alludes to the act of omitting to do something that was required. For instance, failing to make the required repairs to an old structure when you ought to have. The second is misfeasance. It describes the act of carrying out a task incorrectly when it should have been carried out appropriately. For instance, employing inferior material to restore an old structure dramatically increases the chance of a collapse leading to injuries. And the third one is malfeasance. It describes the act of repeating an action that was initially done incorrectly. For instance, restoring an old building with illegal and flammable material could result in an accident and transform the building into a fire trap. Let's take an illustration of negligence. B. The owner of a sizable horse asks his friend A to take care of the animal while he is away. The horse strikes and seriously injures a spectator when A leaves it unattended. Here, it will be stated that A's negligence was what led to the act. So, the amount of damage a party has sustained typically determines the extent of their tortious liability. As a result, the degree and severity of negligence determine the extent of liability under criminal law as well. Now let's see and discuss the essentials of negligence. To establish negligence, the plaintiff must establish three essential elements. The first one is duty of care, the second one is breach of the same duty, and the third one is consequential damage. Now let's discuss duty of care in detail. The legal requirement to avoid putting other people or their property in danger is known as the duty of care. It indicates a legal duty rather than just a moral, religious, or social one. The plaintiff must establish that the defendant owed him a particular legal duty that he violated. Depending on whether the claimant and the offender have a commitment to one another in each case, for someone to be held responsible, it is one of the requirements for negligence. It implies that each person owes another person a duty of care while carrying out an act. The fact that this obligation exists for every activity does not mean that it can be moral, ethical, or religious in nature. Rather, it only applies when there has been neglect. The famous case of Donog versus Stevenson in the year 1932 gave rise to the idea that every one of us has a responsibility to take care of our neighbors and anybody else we may anticipate would be damaged by our actions or inactions. In this instance, it was found that a negligence claim might succeed notwithstanding the fact that there was no contract between the manufacturer and the party who had been harmed. In this famous case of Donog versus Stevenson, even though there was no contract between the parties, a drink customer was still permitted to bring a tortious claim against the producer of the bottle because it had snails in it. It can be said to be the foundation of modern negligence legislation. Following is the rule that Lord Atkin proposed in this particular case. He said that you must take reasonable care to avoid acts or omissions that can reasonably foresee would be likely to injure four neighbors. A defendant only has a duty of care to a plaintiff whose injuries are reasonably foreseeable if the duty is based on the reasonable foreseeability of the injury. Before determining whether the defendant breached his duty of care by acting carelessly, the court first determines whether the risk was foreseeable. If it cannot be stopped, there is no need for intervention. A defendant is only liable for damages that are indubitably foreseeable. Now let's see the second aspect of important essentials. The second aspect is breach of duty to take care. A plaintiff must establish both that the defendant owed him a duty of care and that the defendant broke that duty in order to succeed. By failing to take reasonable care to carry out the commitment, the offender violates the responsibility. A person who owes a duty of care must exercise caution and refrain from disobeying or breaking any obligations, as was in the case Blyth versus Birmingham Waterworks Company. In other words, a person should not act responsibly if they breach an existing duty of care. It simply means failing to maintain a standard of care. In the case of Ramesh Kumar Nayak versus Union of India of the year 1994, it was discovered that the post office's compound wall had not been maintained to the highest standards, which caused it to fall and caused the defendants injuries. The failure of postal authorities to maintain the post office premises, despite having a responsibility to do so, led to the conclusion that they were to blame for the collapse. They were consequently compelled to pay it back. In another case of Municipal Corporation of Delhi versus Subhagwanti, AIR 1966, a very old clock tower that was in the center of a bustling area of Chandni Chowk suddenly collapsed, killing several people. The clock tower was 80 years old, and even though it was not supposed to last 40 to 45 years. In control of the clock tower was the Municipal Corporation of Delhi, which had a duty to look after its residents. They were accountable because they had neglected to restore the clock tower, which was a breach of their duty of care to the public. A person crossing the street died when a branch of a tree that was lying in the middle of the road fell on top of him in the case of Municipal Corporation of Delhi versus Shushila Devi, AIR 1999. It was decided that the Municipal Corporation was responsible in this case as well. Now moving on to the third essential, which talks about the consequential damage to the plaintiff. The fact that the defendant was required to use prudence is insufficient. It is also necessary to prove that the defendant owed the plaintiff a duty of care. In Borhill versus Young, 1943, the complainant was a fishwife who got off a tram. While she was getting help to put the basket on her back, a motorcycle was instantly killed when it collided with a car 15 yards away on the other side of the tram. The plaintiff was unable to observe the deceased or the scene of the collision due to the tram's obstruction. When she arrived at the crash site and saw blood on the road after the dead body had been removed, she realized she had just learned about the accident. As a result, she went through a nervous shock and gave birth to a stillborn child who was 8 months old. She filed a lawsuit against the heirs of the motorcycle rider. The plaintiff was not entitled to file a claim for damages because the court found that the deceased owed the plaintiff no duty of care. It is inadequate to merely have proof of the defendant's negligence. Additionally, it must be demonstrated that the defendant's action caused losses to the plaintiff to whom the defendant owed a duty of care. Now, the harm may fall into the following classes. First one is the bodily harm. Second, harm to the reputation. Third, harm to property. Fourth, financial loss. And fifth, mental harm. The defendant is required to make up the plaintiff's losses when such harm is established. In the 1994 legal proceeding, Joseph versus Dr. George Munjale, the surgeon was fined Rs 1,60,000 by the Kerala High Court for operating on a patient who was 24 years old without using even a local anesthetic or following standard medical procedures. A cotton mop was accidentally inserted within the patient's body due to the doctor's negligence in Achurato Haribhau Kodwa versus State of Maharashtra in the year 1996. The doctor was held responsible in this case as well. Now let's discuss the concept of res ipsa loquitur. Res ipsa loquitur is a Latin phrase that means the thing speaks for itself. The court's ability to determine that the defendant's negligence led to an extraordinary event that later affected the plaintiff is recognized as a type of circumstantial evidence. Although it is often the plaintiff's job to prove that the defendant acted negligently, if the plaintiff offers certain circumstantial evidence, the burden of proof shifts to the defense to prove that the defendant was not negligent. As a result, the three necessary conditions for using this maxim are: the first one is, the damage causing item must be in the defendant's or his servant's hands. Second, if carelessness had not been there, the accident would not have occurred in the normal course of events. And third, there must be no indication of what caused the mishap in the first place. Now let's talk about the remedies for negligence under the law of torts. The main relief in any negligence claim is a verdict of damages. A reasonably foreseeable type of harm must have been done to the claimant. If a reasonable person might have foreseen the exact kind of hurt, loss or damage, the losses are said to be reasonably foreseeable. The burden of proof rests with the claimant to show that the defendant's duty of care was breached. The defendant will need to provide evidence of his innocence given the peculiar circumstances. This will only take place if the harm would not have normally happened if proper care were taken. There is no other explanation for what has occurred, known as res ipsa loquitur, the thing that speaks for itself. And third, the defendant was in control of the situation and the victim was not. Now let's talk about remoteness of damage. Overseas Tank Ship UK versus Mott's Dock and Engineering Company, a case of 1961. The facts of the case are, as a result of the defendant's carelessness, oil leaked and gathered near the roof of the claimant. When the oil caught fire, the roof was damaged. It was held that because damage from fire was unprecedentable as opposed to the damage from oil pollution, the defendants were not found liable under the tort law. If the type of injury was reasonably foreseeable, the defendant is responsible. It is irrelevant whether the defendant could not have foreseen the incident's cause or severity. Now let's discuss the defenses against negligence under the law of torts. The following defenses are possible in a suit for negligence under the law of torts. The first one is contributory negligence. The law of tort allows defendants to assert the defense of contributory negligence when a tort or wrongful act results from the negligence on both the plaintiff's and defendant's side. A person cannot sue another party for an injury that they themselves carelessly caused according to common law, taking into mind that he would be held liable for his misconduct in court. The defendant in Butterfield versus Forrester 1809 construed a pole across a Derby public street without the required permits. The obstacle was still there when the plaintiff was traveling in that direction at 8 p.m. when night fell. He hit the pole while riding carelessly and lost control of the animal. It was determined that because the plaintiff was also negligent, he was not eligible to make a claim for damages. The next defense is act of God or vis major. Natural calamities like tornadoes, earthquakes, volcanoes, and torrential rains are referred to as acts of God. This defense must meet the following two requirements. The first one is that the forces of nature must be active, and second, that the event must not have been expected and must have come as a surprise. It is a direct, strong, unexpected and unstoppable act of nature that even if it had been anticipated, could not have been stopped despite the best efforts of the people. For instance, a storm, an unusual high tide, a rare downfall of rain, etc. In the case of Nicholas versus Marshland in the year 1875, the defendant had several artificial lakes that weren't hastily built or maintained. Due to many reservoirs bursting as a result of a particularly intense thunderstorm, 4 rural bridges were destroyed. As the water leak was the product of divine intervention, it was decided that the defendant was not to be blamed. Next is inevitable accident. When the plaintiff sustains an unexpected injury as a result of an unprecedentable and unavoidable incident, an accident happens despite the defendant exercising reasonable care. By using reasonable caution, the defendant must show that he lacked both the motivation and means to cause harm to the plaintiff. Accidents are regarded as inevitable when they could not have been prevented with reasonable care, caution, and skill. It indicates a bodily accident that cannot be avoided. In Brown versus Kendall, the defendant's dog accidentally poked the plaintiff in the eye while attempting to separate the two fighting dogs. The plaintiff was nearby. The defendant was cleared because it was ruled that the plaintiff's damage was the result of an unavoidable accident. The defendant's groom in Holmes versus Mathur was driving a pair of horses down a public road. The horse started to run very fast and then a dog started to bark. The groom made every effort to manage them, but it was ineffective. The horses knocked the plaintiff to the ground, where he sustained serious wounds. The defendant was absolved of responsibility since it was determined that the incident was an unavoidable accident. The plaintiff and defendant in Stanley versus Paul, reported in 1891, were both members of a shooting group that went out to hunt peasants. The defendant fired at a peasant, hitting it with a round from his pistol, but the shot ricocheted off an oak tree, injuring the plaintiff. Because the accident could not have been prevented, it was decided that the defendant was not to be blamed. Now, to conclude, the tort of carelessness or negligence has its roots in English law and is seen as a very serious offence under Indian law as well. There are two different kinds of negligence, criminal and civil, and each has a different result, as was previously stated. In order to prove carelessness, it's crucial to establish all the conditions such as duty, violation of duty, damages, and actual and proximate cause. The res ipsa loquitur rule of negligence is an important one that courts apply when a careless act is impossible to justify. Additionally, the defendant may respond to a claim made by the plaintiff by raising defenses in a negligence lawsuit. With this, we come to the end of our lecture. Thank you.